Welcome to CMGuide podcast series. I've always been fascinated by how complex construction projects actually get built, but what often goes unseen are the financial gears turning or, unfortunately, sometimes grinding to a halt. Today, we're really pulling back the curtain on one of the most critical and often misunderstood aspects of this industry, how we ensure everyone gets paid. We're doing a deep dive into something absolutely vital for anyone connected with building and construction, particularly if you're operating in New South Wales, the intricate world of security of payment legislation. Our mission today is to truly unpack how these laws work, why they came into being, and what they fundamentally mean for you, whether you're a head contractor, a subcontractor, or even a homeowner. Think of this as your essential shortcut to becoming well-informed on an incredibly complex but undeniably crucial area. When you look at the construction industry globally, there's this persistent, often painful struggle with timely payments. It's not just a minor inconvenience, it's a pervasive issue that can create a devastating domino effect throughout the entire contractual chain. We're talking about restricted cash flow. And for many smaller businesses especially, it can even lead to outright insolvency. This isn't just a hiccup, it's a systemic challenge that ripples through the economy.
That's such an important point. And it's definitely not a new phenomenon or problem that just popped up yesterday. For decades, the construction industry has been plagued by significant payment issues. We've seen various task forces established, and if you go back to 2003, there was even a royal commission specifically highlighting how widespread these payment problems were across all jurisdictions in Australia. The core issue often boils down to two things. First, the hierarchical chain of contracts inherent in construction, where payments flow down from a principal to a head contractor, then to subcontractors, and so on. Second, there's often a significant imbalance in bargaining power, which leaves many smaller players incredibly vulnerable.
Right. The little guys get squeezed.
Exactly. So the fundamental intent behind these security of payment laws, then, is to actively modify payment behavior and strategically shift the risk of insolvency up that contractual chain. Ultimately, it's ensuring that those who do the hard work on the ground actually get paid and critically get paid on time. It's about creating a fairer playing field.
So if I'm understanding correctly, it's about making sure the cash flow actually reaches the people physically building and creating, rather than getting stuck higher up the chain. It sounds like a really fundamental shift, almost a cultural one, in how payments are approached in the industry.
It is precisely that. Imagine a small bricklaying business, let's call them Baza's Bricks, working on a big residential development. If Baza doesn't get paid on time by the head contractor, well, he can't pay his suppliers, he can't pay his crew, and suddenly his entire business is at risk, even if he's done perfect work.
Yeah, it falls apart quickly.
These laws are designed to protect that operational heart of the industry, ensuring that cash flows to where the actual work is being done.
Okay, that paints a really clear picture. Now let's unpack this further and explore the foundation of these laws in Australia. When we talk about security of payment, where did it all truly begin here down under?
New South Wales really led the charge on this in Australia. It was the trailblazer, introducing this groundbreaking legislation way back in 1999. Specifically, it was titled the Building and Construction Industry Security of Payment Act, 1999.
Okay, 1999.
And this act wasn't just a local initiative that stayed within the state borders. It largely became the foundational blueprint, the model, for similar laws that were subsequently adopted across almost all other states and territories in Australia. The one notable exception to this widespread adoption is the Northern Territory.
Ah, okay.
So, for you, the listener, if you gain a solid understanding of the New South Wales Act, you'll find you have a very strong grasp of the core principles that apply across most of the country. It's like learning the core language that many other dialects are based on.
I understand the original and you're mostly set.
Exactly. Historically, when we look at the evolution of these laws, there were broadly two distinct models. What was colloquially known as the East Coast model, pioneered by New South Wales, and the West Coast model, primarily Western Australia's approach. The good news for uniformity, which is crucial for businesses operating across state lines, is that just recently, in August 2022, Western Australia made significant revisions to its own security of payment legislation. They brought it much more closely in line with that East Coast model.
Oh, that's a positive step. More consistency.
A big step, yeah. It's greatly increased uniformity across the country. And efforts towards this uniformity have been ongoing for a while. Back in 2015, the Senate Economics References Committee actually identified significant inconsistencies and issues within the 8 Australian jurisdictions
Right.
and recommended that the Commonwealth enact uniform security of payment legislation. Following that, in 2016, Mr. John Murray AM was appointed by the federal government to conduct a comprehensive review of security of payment laws across Australia. The Murray Review was released in 2017, and it put forward a substantial 86 recommendations for a national scheme.
86. That's comprehensive.
It was, and crucially, it strongly advocated for basing this national scheme on the East Coast model, with a particular emphasis on the New South Wales Security of Payment Act as its foundation. Many states, including New South Wales, then amended their laws based on these recommendations, which gives us the landscape we see today.
Okay.
In terms of current activity, New South Wales, Victoria, and Queensland are currently the 3 most active jurisdictions in terms of annual adjudication applications launched. This really highlights the continued relevance and active use of these laws in those states for resolving payment disputes. People are definitely using them.
So if New South Wales was the pioneer and the act actually came into force in March 2000, what was the specific pressing problem it was trying to solve at that exact moment? What was the catalyst for such a novel and impactful piece of legislation?
It was essentially a continuation of earlier, less successful attempts to protect small and often vulnerable subcontractors. You had this long history of payment problems where larger players in the chain could leverage their power to delay payments, often with devastating consequences for smaller businesses.
Right, the power imbalance again.
Exactly. The Minister for Public Works and Services at the time, in introducing the bill, spoke very passionately about the need for this legislation. He highlighted what he called the un-Australian practice of not paying contractors for work they had undertaken. He specifically emphasized the severe consequences for small subcontractors, people like Bossa, the bricklayer, or Sparky Sam, the electrician, or Pipe Pro plumbers, who often couldn't survive financially when they weren't paid.
Yeah, terrible hardship for families.
Absolutely. It led to significant hardship for them, their employees, and their families. So the core thrust of the bill was quite clear and ambitious. It aimed to reform payment behavior across the entire construction industry, establish fair and balanced payment standards, introduce clear provisions for what are called progress payments, meaning you get paid as the work progresses, and, critically, provide a rapid adjudication process for disputes. The overarching goal was to speed up payments by effectively removing any incentives for parties to delay. Before this act, it could take months, even years, to resolve a payment dispute through traditional court processes, which small businesses simply couldn't afford.
That sounds like a truly noble and necessary goal. But in practical terms, how exactly does it achieve this? What are the actual mechanisms it puts in place to ensure this actually happens on a construction site or with a project?
That's where the genius and sometimes the complexity of the act comes in. It introduces what's often referred to as a dual payment system.
Dual system. Okay.
Yeah, this means it creates a statutory payment system that operates quite independently, yet simultaneously, alongside any existing contractual payment regime that parties might have agreed upon. This is a crucial point. It establishes a statutory right to progress payments, regardless of what your specific contract might say.
So the act overrides the contract if needed.
In terms of the right to claim payment, yes. Even if your contract is vague or silent on payment terms, the Act gives you a clear path to getting paid. And importantly, it goes further by voiding any clauses within contracts that are designed to frustrate its operation.
Like loopholes.
Exactly. The most famous example of this is the infamous paid when paid clause. Previously, these clauses allowed head contractors to delay paying their subcontractors until they themselves had received payment from the principal.
The old pass the buck.
Pretty much. As you can imagine, this caused massive cash flow issues down the chain. The Act renders such clauses null and void. So the fundamental shift here is that a person or entity carrying out construction work, we call the claimant, is now statutorily entitled to progress payments. This truly shifts the risk of non-payment.
Okay, that makes sense. So if I've done the work, say I'm Baz's Bricks on the Grandview Apartments project, and I'm the claimant, how do I actually trigger this process under the Act to get paid? What's the first step? How do I get the ball rolling?
Right. The entire statutory payment claim process kicks off when the person claiming payment, the claimant, serves a valid payment claim on the paying party, who we call the respondent. Now, this isn't just any old invoice. It must adhere to specific guidelines laid out in the Act. Think of it as a special kind of invoice that comes with legal teeth.
Got it. A specific format.
Yes. In terms of timing, claims can be served monthly, starting from the very first day construction work began. Or, if your contract specifies an earlier date within that month, you can use that instead. A significant amendment in 2018 also broadened this, allowing claims to be made from the date a contract is terminated.
Oh, that's important.
Yeah, it closed a previous loophole that could be exploited. Generally, you can only make one claim per month for a given reference date, but any previous unpaid amounts can be carried forward and included in a subsequent claim. It's designed to be a regular, predictable process.
Okay, monthly claims generally.
That's right. Once that payment claim is served, the ball is then squarely in the respondent's court. They must serve what's called a payment schedule. This document is absolutely crucial because it has to clearly identify the payment claim it relates to, state exactly how much, if anything, the respondent intends to pay, and, most importantly, provide clear, detailed reasons for withholding any amount.
Reasons are key.
Absolutely critical. And this is where it gets really interesting and where many disputes take shape. If the respondent fails to serve a payment schedule within the prescribed time, which is typically 10 business days, or even less, if the contract specifies a shorter period, they become liable to pay the entire amount of the original payment claim.
Wow, the whole lot just for missing the deadline.
The whole lot. In that scenario, the claimant then has direct routes. They can either recover the full amount as a debt in court, or they can proceed directly to adjudication to enforce payment. It's a powerful incentive to respond promptly and properly.
No kidding. And just to clarify, because this is New South Wales and there's a big construction industry, when we say business day, is there a specific definition there that takes into account, say, holidays, like Christmas shutdowns?
That's a great question, and yes, there is. The Act defines a business day as any day that is not a Saturday, Sunday, a public holiday, or importantly, the 27th, 28th, 29th, 30th, or 31st of December.
Ah, the Christmas break.
Exactly. This specific inclusion is designed to accommodate the statewide shutdown of the building and construction industry over the Christmas period. It's a little bit of Australian pragmatism, isn't it? Because trying to serve a legal document to a builder during their Christmas break, well, good luck with that.
Huh. Yeah, not likely to go well.
It ensures that parties aren't disadvantaged by holiday periods when these critical statutory timeframes are running.
Okay, so that's the payment claim and schedule. What happens if they do serve a schedule but the claimant disagrees? Or if they schedule a payment but then don't pay?
Right. So let's say the respondent does provide a payment schedule, but you, as the claimant, disagree with the amount they say they'll pay, or perhaps they've issued a schedule but then failed to actually pay the scheduled amount by the due date. That's when you can trigger the adjudication process.
Adjudication. Okay, what exactly is that?
Adjudication is a rapid statutory process designed specifically for the swift resolution of payment disputes under this Act. It's an interim mechanism.
Interim, meaning?
Meaning it's primarily focused on maintaining cash flow during the course of the contract. It doesn't definitively determine the final rights and liabilities of the parties under the contract. Those are left for later, more formal civil proceedings if they become necessary, like arbitration or court action. The goal here is speed, not necessarily ultimate final justice at this stage. It's about getting the money moving.
Pay now, argue later, essentially.
That's the mantra, exactly. To initiate adjudication, you apply to an authorized nominating authority, or ANA.
ANA, who are they?
ANAs are organizations authorized by the government. They play a vital role in nominating the adjudicators, who essentially act as independent statutory certifiers. Their specific role is to determine the amount of the progress payment that is due in that dispute. Timeframes here are tight and critical. The adjudication application must be made quickly, generally within 10 to 20 business days of the relevant events, such as receiving the payment schedule or the payment due date passing.
So you have to act fast.
You do. The adjudicator then typically has just 10 business days to make their determination, although this period can be extended if both parties agree. This is a very, very fast turnaround compared to traditional litigation, which can take years.
10 days. That's incredibly quick.
It is. And the scope for adjudicators is generally limited. They are required to consider only the provisions of the Act, the specific construction contract, the payment claim, and any supporting documents from the claimant, and the payment schedule and supporting documents from the respondent. They can't just introduce new issues off their own bat or rely on their own external knowledge without giving both parties a fair chance to respond. Doing so would violate the principles of natural justice, that fundamental idea of a fair hearing.
So they stick to the documents provided?
Generally, yes. Now, if an adjudicator makes, say, a clerical mistake or accidentally leave something out in their determination, there's something called the slip rule, which allows them to quickly correct these minor errors.
Like fixing a typo.
Exactly. Think of it like hitting undo on a minor typo in a document, or if they accidentally left out a number in a calculation. It allows adjudicators to quickly fix genuine, obvious mistakes without the whole decision being overturned, keeping the process moving fast.
So the core principle here, the driving force behind this entire rapid adjudication process, is pay now, argue later. Correct.
Exactly. And the courts in New South Wales have generally upheld this principle robustly. They've emphasized that an adjudication decision does not need to be perfectly reasonable or absolutely correct in its findings to be enforceable.
Really? Not perfectly correct.
No, as long as it meets the basic, essential requirements of the Act. This reinforces the interim nature of the process. The priority is getting cash flowing, keeping the project moving. Final arguments about correctness can happen later, if needed.
Okay, so what happens if the respondent still doesn't pay after the adjudicator makes a decision?
Good question. If the adjudicated amount isn't paid by the respondent within 5 business days of the decision being served, the claimant can then obtain an adjudication certificate from the ANA. This certificate is incredibly powerful because it can be filed as a judgment for a debt in any court of competent jurisdiction and is enforceable just like any other court judgment.
So it becomes a court order, effectively?
Yes. And furthermore, and this is a really strong incentive for compliance, the claimant gains the statutory right to suspend work on the project.
Suspend work? Wow.
Yeah. Imagine being a head contractor and Sparky Sam just stops all electrical work because you haven't paid the adjudicated amount. This provides a very strong incentive for the respondent to comply with the adjudication decision quickly. Stops the whole project potentially.
I can see how that would focus the mind. It sounds like this legislation isn't just static, it's constantly adapting and evolving in response to real-world issues and challenges that emerge from its use. What were some of the early amendments designed to address?
That's a keen observation, and it's absolutely true. The Act has been tweaked quite a bit over the years. After just 3 years of its operation, insights from its use in practice led to the Building and Construction Industry Security of Payment Amendment Act, 2002. These 2002 amendments provided much-needed clarity regarding timeframes, their application, and the consequences of non-compliance. Notably, a provision in the original statute that allowed respondents to place the determined amount in security or trust until the dispute was finally heard was repealed.
Ah, so no more holding the money aside.
Correct. It required direct payment. This was a significant shift, forcing money to flow immediately rather than being held up in escrow, which defeated the purpose of rapid cash flow. The definition of progress payment was also expanded to include final payments, overcoming a previous court decision that had excluded them from the Act's scope, ensuring the Act covered the entire payment lifecycle right to the end of the job.
Makes sense? What came next?
Then, in 2010, further amendments were made, specifically adding new provisions to the New South Wales Act. These provisions introduced a significant new protection further down the chain. They allowed a claimant, say, a subcontractor, making a claim against a head contractor to require the principal contractor, the one at the top, to withhold money owed to the head contractor.
So the subby could get the principal to hold back funds.
Yes, if the principal owed money to the head contractor for related work, they could be required to withhold that money up to the amount of the payment claim being adjudicated. If the principal contractor failed to withhold that money after being notified, they could then be held liable, along with the head contractor, for the amount owed to the claimant.
That gives subcontractors another layer of security.
It does. The amendments also empowered an adjudicator to direct the respondent to provide information about the identity of any principal contractors with fines for noncompliance. This was a clear move to better protect subcontractors, like our pipe pro plumbers, who might otherwise be caught in a squeeze.
Okay, so steady improvements. What about the 2013 changes? I heard they were quite significant.
They were. The 2013 amendments brought in some really significant shifts, and some with unintended consequences, it has to be said. One of the most impactful was the change regarding what constitutes a payment claim. Previously, a claim had to explicitly state that it was made under the New South Wales Act.
Right, you had to label it clearly.
Yes. After 2013, any invoice or claim for payment that otherwise complied with the basic requirements of the Act was considered a payment claim, even if it wasn't explicitly labeled as such.
Oh, so any invoice could potentially trigger the Act.
Pretty much. And this led to what's often referred to as unintended consequences because parties, particularly respondents, might have received an ordinary invoice from Sparky Sam and not realize it suddenly triggered the strict statutory timeframes of the Act.
Oops.
Yeah, they could potentially miss deadlines and face severe penalties simply because they thought it was just a regular invoice, not a statutory claim demanding a formal payment schedule within 10 days.
Yeah. I can see how that would cause problems.
It did create confusion. The 2013 amendments also established mandatory payment deadlines. Unless the contract specifies an earlier payment, head contractors to principals must now pay no later than 15 business days after a payment claim is submitted.
Okay.
And subcontractors to head contractors must be paid no later than 30 business days. This is about standardizing and shortening payment terms across the board. Another crucial addition in 2013 was the requirement for head contractors to provide a supporting statement when serving a payment claim on the principal.
A supporting statement. What's that?
This statement must declare that all undisputed subcontractor amounts related to the work covered by the claim have been paid.
So the head contractor has to swear they've paid their subs.
Essentially, yes, for undisputed amounts. Failing to provide this statement is an offense, and a payment claim issued without it cannot be relied upon to enforce rights under the New South Wales Act against the principal. This had a direct and immediate impact on head contractors' cash flow, as they could no longer solely rely on receiving payment from principals before paying their own subcontractors. They had to demonstrate they were paying their subs first, or at least concurrently.
That's a big shift in cash flow management for them.
Huge. Furthermore, in 2014, regulations were amended, requiring head contractors on projects with a value of $20 million or more to hold subcontractor retention money in trust accounts.
Retention money. That's the money held back for defects, right?
Exactly. It's a percentage of the contract price withheld until the work is fully complete and defects are rectified. This trust account requirement was a vital step to prevent the loss of retention money due to head contractor insolvency.
Which must happen sometimes.
Sadly, yes. It was a common and devastating issue for subcontractors, where their hard-earned retention money could just disappear if the head contractor went broke. Putting it in trust offered protection.
Okay, so 2013 was busy. What about the more recent changes, say 2018? You mentioned the Murray Review influence.
Yes, in late 2018, the New South Wales Act was again significantly amended, adopting several key recommendations from the Murray Review. These 2018 amendments included crucial changes to the payment claim and adjudication process. Importantly, they reversed that 2013 change about invoices. Payment claims must now expressly state that they are made under the Act.
Ah, back to clear labeling. Good.
Yes, it reduced the confusion that had arisen, a big relief for many. The longest payment terms under subcontracts were further reduced, from 30 down to 20 business days.
Faster payments again.
Exactly. And a major simplification was the removal of the concept of reference dates.
Reference dates, what were they?
Oh, they were a source of much confusion and extensive litigation. Before these amendments, the reference date basically determined when you were legally allowed to make a claim each month. It was a technical minefield. It led to countless disputes because if you got the date wrong, even by a day, your entire claim could be thrown out on a technicality.
Seriously, just for getting the date wrong.
Yes. Removing it was a massive relief for anyone simply trying to get paid for their work. It streamlined things considerably.
Sounds like a very sensible change.
It was. The 2018 amendments also explicitly granted claimants an express right to make a payment claim under the Act even after their contract has been terminated. This is a direct response to and intended to close a loophole identified by the High Court in a previous case, ensuring contractors still had a path to payment even if a project went south and the contract ended abruptly.
Right, so termination doesn't automatically kill your right to claim for work done.
Correct. They also gave courts an express right to set aside an adjudication determination for jurisdictional error, and, importantly, to sever only the parts that are affected by that jurisdictional error.
Sever, meaning chop out the bad bits.
Pretty much. It means valid portions of the determination can stand, rather than the entire decision being quashed just because one part had an error. Makes judicial review more precise and less likely to throw the baby out with the bathwater.
That sounds more efficient.
It is. And a key amendment for the industry was the prohibition on corporations in liquidation from serving payment claims or taking action to enforce them, including applying for adjudication or enforcing an adjudication determination. This resolved a long-standing conflict between New South Wales and Victorian court decisions on this crucial point, providing much-needed clarity when a company goes insolvent during a dispute.
Okay, so clarity on insolvency. What about 2021? More changes then, too.
Yes. In 2021, the Act saw further amendments. A significant change was the expansion of the Act's coverage to allow head contractors under any construction contract, including owner-occupier residential contracts, to now make and adjudicate payment claims under the Act.
Wait, head contractors couldn't claim against homeowners before?
Not under this specific Act, no. Even though their subcontractors could claim against the head contractor on the same residential project, it was an anomaly.
That seems unfair to the builder.
It was seen as such. This change was a major development for builders working on residential projects, like constructing a new home for a family. It brought New South Wales into alignment with Tasmania and Western Australia on this point. For these specific owner-occupier contracts, a shorter payment due date of 10 business days was introduced, compared to the 15 business days for other contracts.
Faster payments for home builders, too.
Yes. Additionally, contracts for residential building work over $20,000 are now required to include information on the operation of the New South Wales Act and relevant regulations via a mandatory security of payment guide. This guide is designed to help homeowners understand their rights and obligations under the Act when they receive a payment claim from their builder. More transparency.
Wow, that's a tremendous amount of evolution over the years, constantly refining and adapting to new challenges and court interpretations. What's the very latest on these laws? I hear there's been another recent, really impactful change that reinforces compliance.
Yes, you're absolutely right. Very recently, in August 2024, significant amendments were made to Section 8 of the New South Wales Act. These amendments aim to close what was seen as a substantial loophole. Previously, a court had held in a case in 2023, actually, that a payment claim relating to residential building work could be valid and enforced under this act, even if the contractor was unlicensed or uninsured, effectively breaching the Home Building Act 1989.
So an unlicensed builder could still use the Security of Payment Act.
According to that court decision, yes. And this raised serious concerns about consumer protections under the Home Building Act, when contractors didn't meet basic licensing and insurance requirements. It seemed to give an unfair advantage to non-compliant builders.
Yeah, that doesn't sound right.
The government agreed. Now, with the 2024 amendment, a person is not entitled to a progress payment under the Security of Payment Act if the construction contract doesn't comply with Section 4 of the Home Building Act, which deals with licensing,
Okay.
or if it involves residential building work done in contravention of Section 92, which specifically requires an insurance policy under the Home Building Compensation Fund. This is a very strong move by the government to reinforce consumer protections and to deter illegal or non-compliant activities in the residential building sector.
So this is a clear message. Comply with the Home Building Act, ensure you're licensed and insured, or you won't get the protection of the Security of Payment Act for your payment claims. This raises an important question. How have the courts reacted to all these changes and the operation of the Act generally? It seems like this rapid, rough-and-ready process often ends up in formal justice, which might seem counterintuitive to its original intent.
That's a fantastic point, and it's a tension that has defined the Act's journey. The Act was indeed initially designed for minimal court involvement, with adjudications intended to be a rough-and-ready dispute resolution process. Quick and dirty, get cash flowing.
Keep it out of the courts.
That was the idea. An adjudication determination could be registered as a judgment, and the grounds for challenging it were very limited. However, over time, courts have seen a rising number of cases where the quality of adjudication decisions was, well, let's just say questionable. This led them to feel increasingly compelled to intervene. This reflects an ongoing dissatisfaction, particularly from respondents, the ones paying, who are usually the ones challenging these decisions, arguing that they didn't receive a fair shake or the process wasn't followed properly.
So the courts started getting more involved despite the Act's intention.
They did. And the ambit of judicial review, how much the courts can look into these decisions, has certainly been a dynamic landscape. A key distinction here, which is often at the heart of court challenges, is between jurisdictional error and non-jurisdictional error.
Okay, what's the difference?
Courts generally only intervene for jurisdictional error. That means the adjudicator acted outside their authority or failed to follow essential statutory requirements, or there was a substantial denial of natural justice, meaning a fair hearing wasn't provided. They typically do not review for simple errors of law or fact. That's non-jurisdictional error. If an adjudicator just gets a number wrong or interprets a contract clause differently to how a court might, that's generally not grounds for overturning the decision. It has to be a more fundamental error in the process or authority.
So process errors, yes. Judgment errors, no.
Broadly speaking, yes. It maintains the interim nature of the adjudication. There have been several landmark cases that have shaped this understanding. In 2003, Musico v. Davenport established that judicial review for jurisdictional error was indeed available. However, a year later, in 2004, Broden Putty Limited v. Davenport initially seemed to narrow the scope, suggesting only a failure to meet basic and essential requirements for a valid determination would lead to a void decision. A bit confusing. But then, in 2010, we saw a pivotal case, Chase Oyster Bar v. Hamo Industries. This case really clarified that state Supreme Courts cannot be prevented by legislation from exercising their supervisory jurisdiction over these statutory processes. They have the power to review for jurisdictional error.
So it's really saying that if an adjudicator steps outside their lane or doesn't follow the process correctly, the courts will definitely step in. They're not going to let a bad process stand, even if the act is meant to be quick.
Precisely.
Yeah.
Post-Chase New South Wales courts have quashed many determinations for jurisdictional error. For example, if a claimant failed to serve required notices properly, or if an adjudicator failed to provide clear intellectual justification for their decision, didn't show they're working, basically, or denied natural justice. By not allowing a party to be heard on a crucial point, the courts would intervene. This effectively told adjudicators, show you're working, follow the rules, or risk your decision being overturned. In 2016, the High Court further clarified this in Southern Hahn Breakfast Point v. Lewis construction. They confirmed that the existence of a reference date, a tricky element in payment claims before the 2018 amendments, was a jurisdictional fact.
Meaning
Meaning if the reference date wasn't valid, the adjudicator lacked jurisdiction from the start and their entire decision could be thrown out. It had to be correct for them to even have the power to decide.
wow, very technical.
Very. Then, in 2018, ProBuild Constructions v. Shade Systems saw the High Court reiterate that courts cannot overturn determinations based on non-jurisdictional errors of law or fact, again reinforcing the interim nature. The message here is consistent. If an adjudicator makes a mistake of law or fact, a non-jurisdictional error, courts generally won't intervene. This underscores that adjudication is about speed and interim cash flow, not necessarily perfect final justice. You get your money, and if you want to argue the finer points later, you go to a different forum.
Okay, so the courts draw a clear line. Can you give some practical examples of how this plays out?
Sure. We've seen many practical applications in real cases. For instance, imagine Grandview Apartments and their head contractor and Bosses Bricks. In a case similar to owner's strata plan 61172 v. Stratabuild Limited back in 2011, the court found the adjudicator made a jurisdictional error. They misinterpreted the act regarding what constituted proper reasons versus just submissions and payment schedule, and they failed to consider all the relevant reports submitted. This case highlights the absolute importance for respondents to provide full, detailed reasons in their payment schedule for every dollar they're withholding. Vague statements just won't cut it.
Gotcha. Be specific.
Very specific. Then, in a case akin to Style Timber Floor PT Ltd v. Krivosudski in 2019, the court emphasized that payment schedules must state reasons for withholding payment with enough detail to inform the claimant of the real issues in dispute. Vague statements like work not complete or disputed simply aren't enough. You need to specify what work, why it's not complete, and how that impacts the payment calculation. Silence or vagueness in your payment schedule is now essentially treated as tacit agreement. If you don't clearly dispute something with reasons, the adjudicator can, and often will, award the full amount without needing to investigate further.
So the onus is really on the respondent to spell it out.
Absolutely. Another example comes from Brolton Group PT Ltd v. Hanson Construction Materials, PT Ltd in 2020. In that case, an incorrect reference date was used by the adjudicator, leading to a void determination, once again emphasizing the critical nature of jurisdictional facts, even after the reference date concept itself was simplified. Get the basics wrong and the whole thing falls over. We also saw Cadia Holdings, PD Ltd v. Downer, EDI Mining, PD Ltd in 2020, which narrowly interpreted the mining exception in the Act. This means many contracts related to mining preparations, site clearing, things like that, are still covered by the Act. The key takeaway here is that if a contract includes any construction work as defined under the Act, it's generally considered a construction contract under the Act. It casts a very wide net.
Interesting. Any others?
Yes, a couple more recent ones are quite telling. In TFM Epping Land, PD Ltd v. Deakin Australia, PD Ltd in 2020, the court clarified that a claimant's technical failure to serve that head contractor's supporting statement with the payment claim does not invalidate the payment claim service itself.
So a minor procedural slip doesn't kill the claim.
Not necessarily that one, no. It prevents a technical breach from derailing the entire claim right at the start, which provides a bit of a safety net for claimants. More recently, in Witron, Australia, Patty Ltd v Turnkey Innovative Engineering Patty Ltd in 2023, an email response from a principal was deemed not a valid payment schedule. Why? Because it failed to explain why payment for all claimed variations was being withheld, even if it justified rejecting payment for the original scope of work.
So you have to address every part of the claim.
Every part you intend to withhold payment for, yes. This again underscores the need for specificity and comprehensiveness in payment schedules. You can't just pick and choose what to explain if you're rejecting multiple items. And in a really important case from 2023, Ciros Petty Ltd v. A Civil As Petty Ltd, the court ruled something quite significant. They said if a respondent doesn't dispute the quality or performance of work in their payment schedule, or if all their stated reasons for withholding payment are rejected by the adjudicator as invalid, then the adjudicator doesn't need to independently verify the work was actually done or done properly. They can just award the full claimed amount based on the lack of a valid dispute in the schedule.
Wow. So the payment schedule is almost everything.
It's incredibly powerful. This decision streamlines the process significantly when respondents fail to properly engage or articulate their reasons in the payment schedule. It really reinforces the importance of getting that initial payment schedule right.
This is a lot of back and forth between the legislative intent for speed and the judicial interpretation for fairness and sometimes technicality. What if a party, typically the respondent, wants to stop the adjudication process entirely or prevent an adjudication certificate from becoming a court judgment? Can they get an injunction?
Yes, an aggrieved respondent can certainly apply for an injunction to restrain the claimant from proceeding with adjudication or from filing an adjudication certificate as a judgment for a jet. An injunction is essentially a court order to stop something, in this case, to stop the adjudication process or to prevent an adjudication decision from being turned into an enforceable court judgment. It's a legal pause button, but courts don't press it lightly.
When would they grant one?
It's often done when there's a strong argument, a prima facie case, that the adjudicator lacked jurisdiction from the outset, or there was a fundamental denial of natural justice that tainted the whole process. However, courts engage in a delicate balancing act here. They weigh the balance of convenience, for instance, the potential harm to a company's reputation if a judgment is recorded against it, versus the claimant's statutory right to rapid payment under the Act. Concerns about a claimant's potential insolvency, the risk that funds might be paid out but then be impossible to recoup if the decision is later overturned, can also influence the court's decision on whether to grant an injunction.
So they weigh up the potential harms.
They do. But it's important to note that courts are generally reluctant to interfere early in the process. They recognize that adjudicators are the primary decision makers under the Act, and the entire system is designed for speed. Often they prefer to let the adjudication proceed, reserving judicial review for the end if necessary, rather than preemptively stopping it and derailing the swift payment mechanism. They tend to let the statutory process run its course first.
Okay, so injunctions are possible, but maybe not common. What about the end game? You said adjudication is interim. How final is it really?
That leads us nicely to the interim nature of these determinations and their finality. If an adjudication determination is found to be void by a court, say due to a jurisdictional error, the Supreme Court does have the discretion to remit the matter back to the original adjudicator for reconsideration.
Send it back to the adjudicator.
Yes, but this raises practical difficulties. By the time a matter is remitted, circumstances might have changed significantly on site, the original payment schedules could be outdated, new issues might have arisen. It can get messy. This also arguably goes against the Act's core intent for speed and efficiency. It can feel like sending an email from 2 years ago back to be reread in the current context, and it might not fit anymore.
Right.
Now, Section 32 of the New South Wales Act acts as a crucial safety net. It explicitly confirms that the adjudication process does not affect the final rights of the parties under the construction contract or in any subsequent civil proceedings. So if an adjudicated amount was paid, but later found not actually due in final court proceedings or arbitration, the courts can order restitution, meaning the money has to be paid back.
So the final word can still be had in court.
Theoretically, yes. However, the reality of finality in practice can be different. For many disputes, especially smaller ones, the adjudication determination does effectively become the final resolution because parties often cannot afford the time and considerable cost of further litigation or arbitration. The money changes hands, and that's often the end of it.
So it's interim in law, but often final in practice for smaller amounts.
That's a good way to put it. But for larger, more substantial disputes involving millions of dollars, aggrieved parties are indeed more likely to seek judicial review or pursue final determination in court due to the significant financial risk involved. So the interim nature is perhaps more pronounced in those big cases.
Okay, that makes sense. Given all this complexity and the court involvement, is the act actually effective? Are people using it?
That's the million-dollar question, isn't it? Well, the annual governmental reports on the operation of the New South Wales Act clearly indicate its continuing popularity as a principal avenue for resolving payment disputes in the construction sector. This is definitely not some dusty, rarely used piece of legislation.
Got numbers.
Yep. For instance, in the 2022-2023 financial year, there were a total of 937 adjudication applications lodged in New South Wales alone.
Nearly 1,000 applications.
Yes. And 501 determinations were issued by adjudicators in that period. These determinations processed significant amounts of money. The total claimed across those applications was nearly $890 million,
Wow.
with an average adjudicated amount per determination of around $443,000.
So significant sums changing hands through this process.
Absolutely. These figures demonstrate that the Act is actively and widely used for resolving these disputes, indicating its ongoing relevance and the industry's reliance on its mechanisms. It's a key part of the landscape.
Okay, so it's popular. What about the future? Are there more reforms on the horizon? You mentioned a bill in 2022 that didn't proceed.
That's right. In terms of the future, there have been recent attempts at further reform. In 2022, as part of New South Wales's broader Construct New South Wales transformation strategy, a draft bill was proposed. The Building and Construction Legislation Amendment Bill 2022. This bill aimed to further strengthen the adjudication process through several key proposals, although, as you said, it ultimately was not passed in that form.
What were some of the key ideas in that bill?
Some of the proposals included providing more transparency to owner-occupiers by requiring claimants to attach a specific homeowner's notice with information about the claim process when they served a claim. It also aimed to lower the threshold for retention money needing to be held in those trust accounts, dropping it from $20 million project value down to $10 million.
So protecting more subcontractors' retention money.
Exactly. A really significant proposal was the introduction of an adjudication review mechanism.
A review? How would that have worked?
It would have allowed both claimants and respondents to seek a merit review of an adjudication decision by another, more senior perhaps, adjudicator. Importantly, though, no new issues or evidence could be raised in that review. It would be based on the original material. This proposal also required that any undisputed amounts from the first adjudication be paid to the claimant immediately, with only the disputed amounts placed into a trust account until the review was finalized.
Interesting. A sort of middle step between adjudication and court.
That seemed to be the idea, trying to find a way to correct potential errors without the full cost and delay of court. The bill also sought to give adjudicators more discretion to arrange for testing of work or materials or to engage experts, which could potentially improve the quality of determinations in complex technical cases.
So what happened to these proposed changes? Were they simply put on hold, or have they been abandoned entirely? Why didn't they proceed?
That's the slightly unclear part. These proposed amendments were eventually dropped from the subsequent 2023 Building Legislation Amendment Bill and have not progressed further since then. The New South Wales government hasn't yet clarified whether these specific reforms will be pursued again in future bills or if they've been shelved indefinitely. It highlights the ongoing debate and the difficulty in finding the perfect balance for this powerful legislation. Industry consultation might have raised concerns or priorities shifted.
So a bit of a question mark there.
A bit of one, yes. And despite the reforms that have been made over the years, some criticisms and potential loopholes persist in the operation of the Act. There are ongoing concerns, for example, about the independence of the authorized nominating authorities, the ANAs, and the adjudicators themselves.
Independence concerns, like...
Well, critics suggest that some ANAs might be perceived as being profit-driven, as their revenue often comes from processing applications, which are usually lodged by claimants. This could lead to a perception of bias towards claimants. There are also persistent allegations, or at least concerns, about adjudicator shopping.
Adjudicator shopping.
Yeah, the idea that a claimant or their representative might try to influence an ANA to appoint, or perhaps not appoint, certain adjudicators based on their perceived leanings or track record, or they might threaten to take their business to another ANA if their preferred adjudicator isn't appointed.
That doesn't sound ideal for fairness.
No, it undermines trust. Imagine a small subcontractor desperate for payment, who feels pressured by an ANA to use a specific claims preparer, with the implication that using their recommended expert will ensure a faster, more favorable adjudication. These sorts of alleged practices raise serious questions about fairness and contravene the fundamental principle that decision-makers should be free from actual or apprehended bias. Another challenge is ensuring sufficient and regular referrals for adjudicators to maintain their expertise. If an adjudicator only handles 1 or 2 cases a year, can they really stay on top of this complex, evolving legislation?
Good point. Consistency is key.
Exactly. And consistent quality assurance of their competences is an ongoing concern. Plus, the financial arrangements between ANAs and the adjudicators they appoint may still need better regulation or transparency to truly protect professional independence and avoid any perception of impropriety.
So still areas for potential improvement.
Definitely. However, we must circle back to the most recent change, which reinforces compliance significantly and shows the government is still very much engaged in refining the system. As we discussed earlier, that June 2024 bill, assented to in August 2024, specifically amends the Act to limit the right to progress payments for construction contracts that don't comply with crucial sections of the Home Building Act 1989. Specifically, Section 4 relating to licensing and Section 92 relating to mandatory home building compensation fund insurance for residential work.
So even without those broader 2022 reforms happening, the government is clearly still actively trying to tighten the act to ensure lawful conduct and proper consumer protections. This is certainly a clear and strong message for everyone in the industry. Compliance is paramount if you want the shield of the Security of Payment Act.
Absolutely. It makes it abundantly clear that the protections and powerful mechanisms of the Security Payment Act are intended for those who operate legally and ethically within the established regulatory framework. It's about leveling the playing field for those who follow the rules, particularly in the residential sector.
We've covered a tremendous amount today, from the Act's pioneering origins in New South Wales to its constant evolution through multiple amendments and the ongoing legal battles that continue to shape its interpretation by the courts. It's truly a complex landscape, but one that is fundamentally designed to ensure fairness and critically cash flow throughout the construction industry. It really is a continuous balancing act between speed and justice, isn't it?
It really is. And what's truly fascinating here, I think, is observing how a piece of legislation, born out of a fairly simple and noble desire to simply ensure that people get paid for the work they've done, has evolved over the decades into such a detailed, nuanced, and let's be honest, often highly litigated framework. It really raises an important question for you, the listener. In an industry so inherently prone to disputes and often characterized by information asymmetry and that imbalance of power we talked about, how can individuals and businesses best balance the immediate, pressing need for rapid payment, which this act provides, with the ever-increasing complexities of compliance and the very real scrutiny of legal challenges that can follow? It's a tough balancing act for everyone involved.
That's a great question to leave our listeners with, a real strategic challenge. Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CMGuide website for better insights on this topic.